I know who my attackers are.
Requested has been fulfilled, and it's still not been fulfilled in regards to their work records and their clock in and clock out times. That's been approved. Nothing's been submitted to the docket, because that's on the plaintiff to supply that.
Um, if I may, on the docket, Your Honor, you said the respondent was responsible to reach out and get that information, not the plaintiff.
That is correct.
So the fact that she's motioning this, or she's saying that this happened, you know, that's she's basically just going off of what her clients told her. But being that we're not going to have any sworn testimony, we're not going to have anything to prove this because none of the witnesses are available, and two, we don't have anything that confirms what she's saying. I mean, it's all
Hey everybody, it's your girl Taro, and welcome back to my channel. Thank you guys so very much for being here. It is very appreciated. If you are new to the channel, hello, my name is Taro. It is great to have you. Please guys, remember to hit that like button. It really helps out the channel. It's a good and free way to support this type of content. Subscribe if you haven't already and you want to, and let's get to the video.
Pause there for a minute.
Alright.
Can you be a little bit? He's just thinking about going to the bathroom, basically.
Okay, no, not a problem.
About I'd say 3 days ago now, I on my last PW, I was having someone put stuff up on a boat for some odd reason. I don't know why. I've yet to question it. And it's one of those boats that are down by the dock, like the really massive container ones. And he wanted to lie on the opposite side of the table. And I tried to get there, and I thought, I'm going to try and jump over the table, and I just kind of jumped over the side. Last thing I know, I seen containers in my face, and then I woke up at the hospital.
Huh. Honestly, that sounds like something I would do.
It was a first for me, and it's the funny thing is, it's one way to leave public works. That's for sure.
Yeah, no kidding.
So,
Crazy. Sorry, go ahead.
no, it's all good. So, yeah, this Friday will be my last day officially in city.
Oh goodness. Why? What's going on?
I took a week off. That's why I haven't been around.
Uh-huh.
And, I kind of was. I kind of got burnt out on the city. I really have. I'm not gonna lie. Since I first flew into about, let's see, when was a week? Till about the 17th. So the 16th, I was flying in every day and doing about 18 hours a day.
Jesus Christ.
Mm-hmm. It's how I made my money. It's how I was able to afford all my cars. Literally, all my money is sunk into vehicles. Also, how I know when a good deal is a good deal and jump on a vehicle. Uh, with everything that's been happening in, jeez, a month ago, I've been kind of keeping it quiet and I haven't said anything. And I know who my attackers are.
The motive? Do you know the motive?
That's the thing nobody knows.
Well, that's kind of bullshit.
I do have a sneaking suspicion I know why they were sent and who sent them. And with the information that I've been gathering since the attack, I've been able to kind of put it together to where I think I know what transpired and why I got attacked. Now, with that being said, I got attacked. I was not the only one that got attacked, which is why I got. What I'm about to say does not leave this room. Please understand that. This can never get out of these walls. I put a hit out on my attackers because I knew who they were. Luckily, the people that did it for me didn't charge me a dime because, well, let's just put it this way. They were close to me. And I consider them family.
All right, how are y'all?
Hi, Doc.
Is streaming you doing all right?
sir.
All right. So, Miss Steele, the deputy chief clerk, she's going to be transcribing the pretrial hearing.
All right.
I understand that there were some motions to address, and
Yes.
there was an issue with one of the plaintiffs that the plaintiff's counsel wanted to address. So I'll solicit those explanations from the plaintiff, and then we'll proceed from there. So let's hear it, Miss Steele.
All right. So, my client, Mr. Bones, he just was in France. You have an operation. He's able to fly in today, but it's still very new. I am not certain that he will be well enough to attend trial tomorrow due to the operation. since Mr. Schumann called him to question on direct, which is the only reason for them to have to be there, considering this is a civil and not a criminal case. I would like to see what we can do about that.
I'll speak up for the benefit of Ms. Steele and I guess the gallery as well. Thank you.
Okay, so.
Oh, I am speaking up, so yeah.
Can you
Oh,
state
wonderful.
again who was the
Mr.
The-
Bones.
Mr.
Alexi Bones, yes.
Okay, and he had an operation in France, and
Yeah.
he's not available, may not be available to attend tomorrow.
May not. Last I know is that you'll be able to fly back sometime this evening, but I'm not sure how well enough he would be to attend trial.
Okay, what about the other plaintiff?
That the time just doesn't work for him of what it's set up as. He has out of city matters.
Okay. So before we begin and get into this lengthy debate, because there are a lot of motions to address, and then I have some topics I want to bring up myself. There was a motion for summary judgment made by plaintiff. The respondent initially did not agree with the request. Another motion was made a couple of days ago. I want to see where the respondent's at on that currently, Mr. Schumann.
Yeah, I mean, I've seen summary judgment be done a few different ways in the state. Most of the time, it's like directed verdict. If she's motioning for a directed verdict, I feel it would be a little more appropriate. If that's what she's wanting to do. But for summary judgment, speaking with the officers involved, so my clients, they're not comfortable with that. They want to testify and they want their voices to be heard and they want to address the allegations. Because they're, they're just in the claim. They are dramatic, and there's a lot of things that are presented as facts that are simply just not true, and they're willing to testify to those matters. So we're not really wanting to do summary judgment.
So the way I would conduct summary judgment, and this is different from other judges, I understand, but I would have both parties get together and submit to the court a list of undisputed facts for the court to consider. So those are facts that neither the plaintiff or the respondent are going to dispute, and the court will take those into consideration. The parties would have the opportunity to depose the witnesses and submit those depositions, that testimony into evidence, and then you'd be able to submit your written arguments on the docket. And the court would consider the depositions as evidence, the affidavits, the testimony provided in the affidavits as evidence, and the statement of facts, and obviously the arguments presented by the plaintiff and the respondent. So the evidence would still be there, the testimony would still be there. We just wouldn't have an in-person hearing. It seems to be very troublesome to get both plaintiffs who were subpoenaed by the respondent to attend trial. Now, whether or not there's a willingness to prosecute the case, I'm going to look into that. I'm going to ask Ms. Stowe about that later. But that's how we'll conduct summary judgment if, Mr. Schumann, that's what you decided to do, if you decided to agree with that. So the procedures, the court has no authority to order summary judgment. Both parties have to agree to it, and the court has to accept it. So with that in mind, Mr. Schumann, are you willing to consider summary judgment now, or do you still want to proceed to trial?
Still proceed to trial, Your Honor.
Okay. That makes our time a little bit more difficult. So now that the issue of summary judgment's out of the way, Ms. Stowe, there was another issue you wanted to bring up as well, I believe. Let me look at the docket.
I mean, the only other thing I put in that would be to release the subpoena for Louis DeWitt. That was the only other one I put in there, minus the summary judgment and the case with my client.
Okay. So that was the only other thing was
Yes.
release Mr. DeWitt. Okay.
Mhm.
So Mr. Schumann and Ms. Stowe, since the parties aren't agreeing to do a summary judgment and they want to go to trial, the court will have to consider the evidence that has been submitted so far. As a matter of fact, I think the evidence submitted so far is outside of the discovery period. The ones that were submitted today, the affidavits, and then there were some images submitted. I'd have to look at my order, but I think I said evidence must be submitted 48 hours before trial. Trial is tomorrow. So that puts us 48 hours closer in the time frame of 48 hours to trial. So the evidence could not be considered that was submitted today. Um, that also includes the testimony of the witnesses that were unavailable to attend trial. That includes one of the plaintiffs, and I believe Mr. Zito, and the nurse practitioner, which I understand there was an affidavit submitted for the nurse practitioner, but again, that
Yeah,
can't be
I
considered by the
struggled to get
court.
a hold of her, sleep schedules, but I understand if it's not accepted.
So this would greatly prejudice the case for you, Mr. Schumann. Do you understand?
Yeah, I mean,
Oh,
I've got
shit.
a motion once we do all this, but the respondent's going to be moving for either a mistrial or a motion to dismiss because of what's on docket right now. But I'll just let us figure all this out first.
Okay. All right, before we get to those motions, Ms. Stowe, do you have anything else for the court to consider?
I do not.
Okay. All right, Mr. Schumann.
All right. So, first motion we're going to do is motion to dismiss with prejudice. Based off the facts and circumstances that are provided on docket, along with all the exhibits that have been submitted, the plaintiff has failed to meet any type of burden of proof. Not even, I don't even believe that the court should. I don't even think the court should entertain this this claim because even just looking at the claim along with the evidence that's been submitted, it's there's no negligence. So again, it's something that is grounds for dismissal. So that's our motion to dismiss.
Okay, I'll take the motion under advisement for the time being. Do you have any other motions for the court to consider?
Based off of how that goes, will be dependent on our future motions. Also, to add on to that, if the plaintiffs aren't able to make it to court, being that they are subpoenaed on behalf of the respondent, that's another grounds for our dismissal. Being primary witnesses and being subpoenaed, as we are going to question them in regarding the incident. If they're not able to make it, then again, we're not able to make a case and we're not able to defend ourselves adequately, as is our right, given court procedures. It seems like there's a lot of things going wrong with this case. And I feel as if the plaintiffs aren't really interested in this case anymore either. And that's not anything against Counselor Stowe, but that's just what I'm getting off of with all the issues that keep arising.
Okay. To address the plaintiffs who are under subpoena and cannot appear, the court informed both parties on April 14th of the unavailability of some witnesses. That was in the private email conversation that I initiated. And in there, Plaintiff Olson was not available as well. So it was incumbent upon the respondent to seek testimony in whatever form, whether it be through affidavit or deposition, to submit that testimony to the court. Have you made any attempts to get in contact with Plaintiff Olson, Mr. Schumann?
I have not, Your Honor, but we've also there's nothing to talk to him about just yet until our first subpoena that we requested has been fulfilled, and it's still not been fulfilled in regards to their work records and their clock in and clock out times. That's been approved. Nothing's been submitted to the docket, because that's on the plaintiff to supply that.
If I may, on the docket, Your Honor, you said the respondent was responsible to reach out and get that information, not the plaintiff.
That is correct. Mr. Schumann, the court issued this issued this subpoena. I will admit that the court made an error. That the contents of the subpoena were ambiguous. The court should have solicited dates and times that you were requesting, but the court basically gave you the authority to seek out all dates and times for all leaves of absence and other clock in and clock out dates for their employers, and the court ordered you to present to the chief executives of the employers the subpoena and to obtain that information by April 14th.
Okay. Either way, everything else that I've stated is still has grounds.
So the subpoena that the court issued, you did not serve the subpoena upon the parties. Is that correct?
It was under. I believe that it was the responsibility of the plaintiff because I was subpoenaing the plaintiff. I wasn't subpoenaing their employees. So that is how I wrote the subpoena, was subpoenaing Olson and Bones, not their. I wasn't subpoenaing the flight authority. So again, I don't believe it should. It's not my responsibility to now go on, the court's behalf and do that. That's not my, in my opinion, that's not my job. Because again, it was directed at the plaintiffs. It wasn't directed at the flight authority, for example.
Mr. Schuman, if you look at line 31, the court made it your job. I quote it: "The respondent shall provide the above named entities, the employers of the plaintiffs, the above a copy of this subpoena forthwith, and the order shall be fulfilled no later than the end of Sunday, April 14th, 2024. Whether or not you feel it's your job is irrelevant. The court ordered you to provide the entities a copy of the subpoena. The court granted you access to the records, and you didn't fulfill the order. Is that understood? Do we have any other motions from the respondent?
Yeah, it just depends on how the rest our other motion was, how that goes. So we'll.
Okay, I will deliberate on the motion to dismiss with prejudice.
Can
and,
I rebuttal to that?
Yes, I was going to give you the opportunity to here in just a second.
Okay.
But I will deliberate on that, and then how that'll occur. I'll go back into the chambers. I'll research, perform some computerized research, and then I'll come back out and issue my order. And then if the respondent wants to issue another motion, if the dismissal is denied, then he can do that. But Ms. Stutt, you have an opportunity to rebut to the motion.
Thank you, Your Honor. So I would like to bring attention to Exhibit D1 to D3 that I submitted to the docket on line 27. It's the pictures of the road that the incident occurred on. This is a 4-lane road with a medium in the center. Where the collision happened was on the far right lane in the oncoming lane of traffic. That is not simply a had control of a vehicle. For someone to have swerved so drastically in across 3 to 4 lanes, I believe that this motion to dismiss is not relevant. Due to, in order to do that, you had to have lost control of your vehicle, if not already driving on the incoming bound lane of traffic.
We can rebut again, Your Honor, if needed.
I'll permit one rebuttal from the respondent, and then I'll go into deliberation. Mr. Schuman.
So again, based off of the non-availability of the testimony, everything that she just said is not going to be provable. There's no affidavits, there's no witnesses that are going to come and testify to that. All of the witnesses that are available were there after the fact. So the fact that she's motioning this, or she's saying that this happened, that's she's basically just going off of what her clients told her. But being that we're not going to have any sworn testimony, we're not going to have anything to prove this, because none of the witnesses are available, and 2, we don't have anything that confirms what she's saying. I mean, it's all hearsay. It's all just, there's nothing that backs up what's being said right now. None of the allegations are backed by facts or sworn testimony.
Okay. Well, I hasten to remind you, Mr. Schuman, that the burden was on you. You are the one who subpoenaed the witnesses, the plaintiffs, the witnesses to this event. That's your obligation to seek testimonies from them, not the plaintiffs.
I mean, if they're not available, it's not on me to get their testimony. I mean, if she cannot meet the burden that's required in civil court, I'm not going to do her job for her, Your Honor. That's not how it works.
That is how it works. You subpoenaed them. You seek their depositions. You submit their depositions into evidence, or in some other form of testimony. They're here to prosecute the case. They don't have to say a single solitary word if they don't want to. You are the one who subpoenaed them.
Your Honor, I'm the respondent in this case. I'm not the plaintiff.
You
I
subpoenaed
respond.
them.
That doesn't matter, Your Honor. I've subpoenaed their witness testimony, their sworn statement, in court. I did not subpoena for their written statement. You know, if they're not available for in-person testimony, then, you know, I'll release them from their subpoena right now. But again, we want in-person testimony. That is as a respondent, right to face their accusers. And that's what we want to do. If they want to be making said allegations, they should have to come down to court. They should have to back the allegations that they're making. And if we don't do this, we're creating a pretty dangerous precedent here. Let's just take into account everything that's going on right now.
The only part that the court takes issue with is the fact that you subpoenaed them to testify. You are seeking their examination, and you did not, despite being made aware of their unavailability, you did not seek to depose them or get affidavits from them or other form of testimony. That's what the court has issue with respect to your dismissal.
Your Honor, again, it is not my job to do that for her. If she has not met the burden of proof, which I believe very confidently she is not going to be able to tomorrow in court because the witnesses are not going to be available. The only witnesses are going to be available are after the fact witnesses. It is not on me to go and solicit their statements because it is normal strategy in civil court to subpoena all the witnesses and then pretrial motions release subpoenas that are not, the people that were not able to attend, because we don't want them criminally, or we don't want any type of sanctions or anything like that. So again, those people are going to be released from subpoena prior to court tomorrow, or during pretrial pretrial motions. But again, it's not my job to solicit a
Deposition, yeah, sweetie. It is.
a written affidavit from them. It's or to anything along those or in that regard.
Okay. The court will take the arguments under consideration, and I'll be back in probably 10-15 minutes. So
Yes,
just give
Your
me some time.
Free food.
Hello. What?
Hello. Who might I had some?
Okay, so would you like some?
Yes. Of course
Okay,
I
I
like
have honey
free things
barbecued
with
pulled
stove.
pork sandwiches if you want that.
Oh, anything. I'll take any. I love free things.
There you go.
Thank you so much.
You're
Too
welcome.
kind. Very kind. Miss Stowe, I have to say, I think there is a very fortunate thing for you that Mr. Schumann has an ability to piss off the judge.
Oh, I know.
Because he had a very good point, I think, but I think the judge thinks he's arguing about the deposition thing still, which has pissed him off, and Schumann
No,
hasn't
I know he has a
redirected
very
that.
good point. Yeah.
But Schumann hasn't redirected that and continued fighting against it, so it's
Well,
like
my main thing
terribly
is
right to him.
he was too focused on the affidavit. He could have done the other one where you had to ask questions directly to him, but he didn't.
Deposition.
A deposition, yeah, but he didn't.
Yeah.
So
Yeah, but I think what he was trying to say is you yourself don't have any testimony from them to like any testimony in regards to the actual incident that happened. Everyone's after, which I think is a decent. I didn't read the docket, but I think that's a decent point if that's obviously true. But yeah, but
oh yeah, I have
he,
no
like,
testimony considering I was told. But hey,
yeah, but that's okay because he fought it. I think he didn't redirect the judge to what he actually meant. So I think the judge thinks he's just fighting him about the deposition. So I think it's really good for you.
we'll see what the judge says. Either way,
Yeah.
I'm just ready for this all to be done so I can finally step away.
Yeah, that's fair. You've been fucking trying to leave for ages.
Jeez, yeah.
Hey, so you gave me something.
Nah, we'll see what the judge says. But no, he had a good point there, and I felt like I would have made that argument. But I'm just doing my job. And like you said, there's no quarrel against me, myself. I'm just doing what I'm paid to do, so.
Of course. Well, it's the court and order group, so you're not getting paid all that much to do it, but...
Not really. But I explained to my clients, I'm like, listen, if it gets dismissed today or if we lose tomorrow in court, it's the same outcome. You're just not getting any money.
Yeah, no, absolutely fair. Just spends less time. But I'm not really caught up with this case. I read it initially when you asked me to give you my opinion, but that was such a long time ago.
Oh yeah,
Um, it was like probably only
that
three
was a
weeks.
couple of months ago at this point.
Yeah, something like that. But anyway, so
Hmm.
I don't quite recall the facts. But is it? Do you think it's like if it actually goes to trial, it's all you have a chance or no?
I do think I'll have a chance. Because like I said, yeah, there's no burden of fact. But here's the thing: they were on the um side oncoming traffic. He was driving into oncoming traffic of a 4-lane intersection.
Hmm, that's
And
true.
that turn is not a sharp turn, it's a wide turn, mind you.
That's very true.
So I'm sorry, the only way to cause an accident like that is to have lost control of your vehicle, if not already be driving in oncoming traffic.
Yeah, it's just the issues without the plaintiffs. It's you only have the police's testimony, I guess, which could be enough, but difficult.
Yeah, I'm aware of that. But like I said, Alexi's help, I can see if he's able to make it tomorrow, if he feels up to it. Like I told the judge.
Mm,
He's flying back in, but I'm not sure how well he will be to attend trial.
yeah, that's fair.
Okay, the court has considered the respondent's motion to dismiss with prejudice. The respondent claims that the plaintiff failed to meet the burden and that the court should not entertain the claim because there's no evidence of negligence. What the court has to consider is whether the plaintiff stated a claim and presented facts in support of that claim. And if we look at line 27, the plaintiff submitted medical records, which I don't think are being disputed, that the plaintiffs were injured. There's a police report where the author of the report makes mention of a crash involving the plaintiffs, and so the court believes that there is a claim to be made, and accordingly the motion is denied. Does
Yes.
the respondent have any other motions for the court to consider?
Yes, Your Honor. When it comes to the affidavits that have been submitted today, would, um, you know, if us, the respondent, agree to have the plaintiffs, you know, exhibit that they submitted today, if we're both in agreement that we'd like to enter those into, you know, an extended discovery with your permission, would you be okay with that if we submitted both of those, if those can be submitted in the court?
Let me take a look at the evidence that's been submitted today. Give me 1 second. Okay, Ms. Stowe, am I correct that you have submitted an affidavit from nurse practitioner Wren today?
Yes, Your Honor, I have.
Okay, Mr. Schuman, you have submitted an affidavit from Ms. Beckett. I believe that's the medical responder.
Yes.
And then you submitted 3 text messages, photographs.
Yes.
Give me 1 second. Let me look at these text messages. While I do that, Ms. Stowe, do you have any objections to the evidence that's been submitted by the respondent?
I do, Your Honor. He submitted that these text messages are to correlate with what Miss Beckett's affidavit stated. Nowhere in here in these text messages does it say that this purchase of this aircraft was directly related to suing because they were scrapped on cash. I have spoken with my clients. They have been in works of acquiring this aircraft because Mr. Olson is a private commercial pilot. It is better to have his own plane than to rent one, and he's been in the works of getting money for this well before this incident happened. I would also like to add there's no date as to when these texts were received. It just says yesterday and stuff and along those lines. There's no actual date.
Your Honor, I mean, if you accept them, then you can take all of her points into consideration. You know, we can bring our issues up in trial tomorrow, and how they correlate. But again, just being accepted into, accepted in, you know, in discovery, and then we can make our points tomorrow with witness testimony.
Okay, Mr. Schuman, how long have you been in possession of the affidavit?
I'm not sure, Your Honor. I was just able to submit it when I saw she submitted an affidavit today.
Okay, it's dated April 5th, 2025. We're obviously
2025.
we're also in 2024. So is that date correct? And have you been in possession of this affidavit since April 5th?
I mean, clearly the date's not correct if it's 2025, so
All right, can you advise the court when you came into possession of the affidavit?
I wouldn't be able to tell you. I have no idea. It'd take me too long to find when I got it.
The court can wait. I'm just interested in if this was submitted April 5th of this year, and this has been available to you, the court's not going to permit it. That's first of all, it would be against the court's order for the entrance of evidence past the discovery period. And I mean, if the respondent's been in possession of it since the 5th, well, you've had since the 5th to submit it.
I believe I got it on the 17th, Your Honor, so about a week ago, and I was only able to get it uploaded today due to outside circumstances. That's all I can find on it right now.
Okay, all of the evidence submitted today is denied. Are there any other motions to consider?
I have one. I would like to see about taking 2024 CV007 into consideration as case law.
Okay, I saw the introduction of that. It's noted. All right, to address the issues of subpoenas, Mr. Schuman, you made it aware that you were releasing the plaintiffs from their subpoenas. Is that still accurate?
That's unknown yet, Your Honor, until tomorrow during pretrial motions. I'll advise the court then.
Well, we have we can't wait until pretrial motions. We need to know if you're still going to request their appearance at trial, or rather compel their appearance at trial.
Your Honor, if I can see about Mr. Bones, since he did fly back in, if he is able to show up to testify tomorrow under the consideration that he is one of the first to speak due to being a bit out of it and a bit groggy from surgery and the illness that he went in for.
Is that something you can make the court aware of now?
I can ask. Give me 1 second to reach out to him.
While she's doing that, Mr. Schuman, just make the consideration, please, and I'll need an answer for your subpoenas by the end of the conference today.
Your Honor, I'm not going to have an answer, and if you'd like to file a sanction, that's fine, and I'll put in for an interlocutory appeal regarding it. I'm not going to answer it by the end of the conference.
So let me just make this clear, Mr. Schuman, because you're starting to piss me off. You are saying that you're not going to state whether or not you're going to maintain your subpoenas for the plaintiffs in this case. The subpoenas that, number one, they've already told you that they're going to be unavailable, and number two, we're having trouble getting one of the plaintiffs here.
Your Honor, I'm unsure why we scheduled the court date in the first place when they weren't available.
Because this case has been going on for 2 months.
Okay, it's civil. It's a civil case. It can go on for as long as it needs to.
I don't want it on my doctor for 2 months. That's why I scheduled it.
Okay, Your Honor. Well, then that sounds like again. I don't
Ooh,
mean to be disrespectful.
Schuman,
It sounds
holy
like it is
shit.
a personal issue with yourself and not the best interest of the plaintiff and the respondent.
No, it's what the court has determined is the best date. That was the date where most time was available. You had a week and a half to schedule depositions for these witnesses. This is self-inflicted prejudice on yourself. I don't understand why you think that you don't need to get depositions from the witnesses who you've subpoenaed, I hasten to remind you, and you think that it's not your job to fulfill subpoenas that the court has ordered you to fulfill. This is ridiculous. This whole hearing is ridiculous.
I didn't request this hearing, Your Honor. I wanted to appear in
what
trial
you
tomorrow.
said in this hearing is ridiculous because the court ordered you to fulfill a subpoena. You said that's not your job. It's the court's job or it's the plaintiff's job. Everything else is not your job. When clearly it is. You're putting the burden that is supposed to be on you onto everyone else but yourself.
Your Honor, we're the respondent in this case. The burden isn't on us.
The burden
if we're a criminal,
I'm not talking about the burden to prove the case. I'm talking about the subpoena that you requested, the depositions for the witnesses who you subpoenaed. That is your burden.
If I may interrupt, Your Honor, Mr. Bones would be able to make it. I just request that he be one of the first to testify, just in case if he's really tired from his travels and the surgery.
Okay.
But he's able to make it.
All right, that would be, that's at 7, right?
EST, yes, Your Honor.
Okay. Counselor Schuman, was you agreed to allowing Mr. Bones to testify as the first witness?
That's completely fine, Your Honor.
Okay.
And this is Trooper Zito, Your Honor, that's sitting beside me. he can make it tomorrow, but he will be 20 minutes or 15 or 20 minutes late. You can talk to him about that personally, but as long as
Okay, who's subpoenaed him?
Myself.
Okay, Miss Stowe, you didn't subpoena Trooper Zito?
I'm gonna go back and look, just to make sure. No, Your Honor, I did not.
Okay, all right, that's fine. I'm sure it'll take some time for your witness. What witnesses do you have, Miss Stowe?
So I subpoenaed Talia Beckett, which, you know, with that, I was unaware that they were not able to make it. So that's why I didn't get any affidavit from them. Nick Carter, I already released Louis DeWitt. Maisie Ren Freeman, Sky Rivers. So,
Okay.
yeah.
And Maisie Wren Freeman, she's the nurse practitioner who's
Yes.
also unavailable to make it.
Yes, I was trying for a good couple of days to get a hold of her to get this done. It just didn't line up, and I'm more than happy to drop that affidavit.
Okay, give me 1 second.
Who did you say all in your witness list can't be there?
Oh, let me pull that up again. I just minimized it. So, I'm dropping Louis DeWitt. You put in affidavit for Miss Beckett, and then Maisie is not able to. So that's Nick and Sky.
What were their significance there?
Nick was a part of the pursuit, and Sky Rivers is one of the nurses that assisted with treating of the injuries. Doctor nurses that assisted with the injuries. Yeah.
All right, given all of everything that's been going on, are you still willing to do summary judgment, being how he described it?
I'm more than happy to do a summary job. I'm going to be honest with you, if it makes it easier on Mr. Bones, because he had a very intensive surgery in France. He's not doing well now.
The reason why I wanted them in person is because it's not the same when we're doing it's not.
I understand. His health took a turn very quickly, and it was unexpected to all of us.
Okay.
So I understand.
So you're
completely.
okay with it if we go back to the summary judgment thing?
The way that the judge has described it, I'm perfectly fine with it. Honestly, I am. If it makes it easier on my client, especially with his health and everything, I'm okay with it.
All right, because it opens up, being that he just had a surgery, it opens it up to us. It opens up question to his testimony and if it's reliable. So if we can give him a few more days to recover and then do his testimony or get his statement, then that would be better.
I'm fine to do it the way that the judge offered if you are in agreement.
Yeah, that's fine. Your Honor.
Yes, sir.
I just spoke with the plaintiff in this case. Would you be willing, now that we've, everything that's happened, and then I've just spoke with her, given Mr. Bones' medical issues, his testimony could be called into question tomorrow, and then given Trooper Zito's, he's going to be late. I just don't want to risk it. And would you be willing to go back to that and allow a summary judgment for this case?
Yes,
so we
sir.
get all the witness testimony.
And work on facts that are undisputed. You would submit those to the court. It would be a joint statement, okay, of facts that are undisputed, that both parties are not disputing, and then you would present your arguments to the court. And I would further instruct y'all on the docket if that's what y'all chose to do.
I'm in agreement with this.
So, how long will we have to get all of these depositions done?
What do y'all think is a reasonable time? Y'all know the parties better than I do.
I'm pretty sure I'll be able to get both my clients to be able to do theirs roughly about the same day. I just need to speak with them briefly. I can have an answer for Mr. Schumann within 24 hours at least.
Okay. I'm fine doing the summary. Mr. Schumann, I'm sympathetic to your scheduling issues. I'm very aware, and I don't want to impede with anything you've got going on elsewhere. But we're talking weeks, not days.
Yeah, if we've got weeks, Your Honor, then the state or the respondent is okay with that.
Okay, so y'all are both okay with the summary judgment ruling?
Yes, I've already brought it up with my clients as well as a possibility, and they're fine with that too.
Okay, all right. Well, anything else to consider? Because when I go to post on the docket, there's going to be that really annuls a lot of the stuff we did here today. So we're going to I'll have to go through the transcript again and listen to that and see what still stands valid.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.